Good morning, everyone. I, on behalf of Beyond Law CLC and UILS Punjab University Chandigarh, welcome you all to yet another engaging session. And this time we thought that let's have two legal luminaries who have created their own niche, and not only by their judgments, as well as whenever they have gone to the different sessions, they have been given us. Different perspective of judicial reforms, their judgments have been path-breaking. It will be unfair on my part if I refer to few judgments, because each judgment is a judgment which has its own perspective, which is appreciated not only by the lawyers, professionals, students, professors. It is being considered as a benchmark for not only in the legal fraternity, but everywhere. Their judgments have been like when Justice MADAN LOKUR was the judge of the Supreme Court of India. His bench was also known as social bench because his judgments were path-breaking for social reforms and judicial reforms. Justice Muralidhar's popularity, we all know that when he came to our High Court of Punjab and Haryana High Court, the tremendous response in his farewell and his welcome is a testimony of the fact regarding his popularity because of his judgments. As once I read that bar is the barometer, and the barometer for both of them, Justice Muralidhar and Justice MADAN LOKUR, speaks volume for them. And Justice LOKUR is now a judge of the Supreme Court of Fiji. It testifies the fact that what was the loss of the judiciary of Punjab, of the Supreme Court of India, because of his superannuation, of course, is a welcome treat for the Fijis. But we are lucky enough to have him on this platform. His insights on the judicial reforms and of Justice Muralidhar, I suppose, would go a long, long way. And sir, before we start the session, I would like to tell you this fantastic response we have never got. We were not able to touch the 500, and the session has just started off. Yes, what we say, abhi to party shuru hui hai. So over to you, and Mr. Balram Gupta will just give a brief introduction to the same, because everybody is just latching upon. Fortunately or unfortunately, I've given my mobile number for calling of the questions. Since the day I posted my mobile number, the mobile number with the WhatsApp chat is on and on. Therefore, we have said that you have to post your messages on the Zoom chat. Only one condition I'm saying. Firstly, you have to enter with the name itself and change. You can go out of the this participation, come with the name, because in a given circumstance, it could be that we would have to remove that person because of some people playing a spoil sport in this participation. All healthy criticism and all healthy chats would be welcome. We will ask Justice MADAN LOKUR and Justice Muralidhar to give their insights. I would just say both names start with M, and we will say MM means mindful mindsets for today. Over to you, Mr. Balram Gupta, and welcome to both of you.
Thank you.
Thank you, Vikas. Thank you, Vikas. This morning, we are going to engage ourselves in a dialogue relating to judicial reforms a way ahead. Justice is the greatest human society. Justice is the first promise of the Indian Constitution. Article 142 mandates complete justice in different situations to be carried out. And in that particular process, when we find the people hungry for justice, this particular topic of judicial reforms assumes significance. It is the challenge of the day as such. And in order to have a better perspective in this particular context, we have with us Justice MADAN B. LOKUR and Justice S.MURALIDHAR. May I request to begin with a presentation of 10 to 15 minutes by Justice MADAN LOKUR, followed by Justice Muralidhar, and then we will have an interactive session, live questions to be taken. Over to Justice Madan LOKUR.
Yeah. Can you hear me? Can you hear me?
Yes, I can.
Okay, because
Yes.
the picture seems to be frozen at my end.
No, sir, it's audible. Before you, sir, take over, we would like to inform to the participants that we will be only taking questions which are relevant with the judicial reforms. We will not take any questions like what is your take on Arnab Goswami's bail or any other judgment for that matter. No relations with Arnab Goswami as such. It's just a take for you that we will not ask any comment upon the judgments, etc. We will just ask the way ahead forward. How do we go for the virtual platform? After this testing and trying times, how do we go forward? How do we go for the judicial system? Over to you, Justice Madan LOKUR. Thank you.
Okay. Yeah, thank you. Thank you. And good morning to everybody. I think the response has really been overwhelming. My laptop shows something like 564 participants.
No, sir, 776.
Sorry?
776.
Wow, that's terrific.
And we are going on Facebook Live because we have the capacity of 1,000 people. We're just going on Facebook Live.
Yeah, that's fantastic. For some reason, my screen seems to be frozen, but anyway, 700 is incredible. Just as a sort of a background, one of the suggestions that was given was that we should speak about judicial reforms. But when I spoke to Justice Muralidhar and requested him also to participate in the program, we felt that it would be more important to get your inputs as individuals who are likely to become future judges and future senior lawyers and so on. How do you see the justice delivery system progressing? So I think your inputs are very, very important. So I would request all of you that whatever suggestions you have, please give them to Vikas or to Professor Balram Gupta, and we'll try and see to what extent we can perhaps respond to those suggestions. There are just three things that I would like to say because of the fact that only 10 or 15 minutes have been given. One is that, all of us need to marshal our resources. I think
So
that...
probably you have closed the video.
Sorry?
Probably you have closed the video on your end.
My screen is frozen, Vikas.
It's okay.
Yeah.
Your voice will spread the message. It will be loud and clear.
Okay. Yeah. So, the first thing is I think we should marshal our resources. If we are going to plan for the future, we must know what are the existing resources that we have and how we can build upon these resources, how we can add to them, how we can modify them. Now, some of the resources that I have noted are, apart from the conventional and traditional courts that we are all used to, we have a very vibrant Lok Adalat system. I think we need to cash in on that. We have, under the Legal Services Authorities Act, permanent Lok Adalats. Now, I don't know, but my impression is that these are not functioning as they should be, nor are they in an adequate number. They've not been established everywhere. So I think we need to utilize that resource also. Legal aid and advice, I think, is very, very important. Why should everybody have to come to court? We need to ask that question. Particularly poor people, particularly indigent people, disadvantaged people. First of all, they cannot afford it. They don't have the time. Some of them are daily wagers, so they have to forego a day's wages. We can strengthen our legal aid and advice system so that proper legal aid is given, proper advice is given, so that to the extent possible, litigation is avoided. I think that's a social responsibility that all of us as members of the legal fraternity have, and I think we should discharge that responsibility. The next resource that we have is alternative dispute resolution mechanisms. Arbitration is one area that is talked about a lot. Sure, we can strengthen that. There are countries like Singapore, which perhaps started off with not much, but now they are among the leaders in the world. The London Center for International Arbitration wanted to open up an office. In fact, they did open up an office in India, but then eventually closed it. Why can't we strengthen our arbitration laws, our arbitration procedures, institutionalize arbitration so that it becomes more responsive to the needs of the commercial community. Mediation is another great way of resolving disputes. It will cut out litigation. It will give satisfaction to everybody, to all the parties. It is said it's a win-win situation. So again, that's a resource that is existing in addition to arbitration, and I think we should again, capitalize on that. We have tribunals and commissions, consumer commissions, for example. Can we not strengthen them? We have so many tribunals. National Green Tribunal, for example, there are so many benches of the National Green Tribunal that are lying, vacant because of vacancies, non-appointments. There are any number of tribunals. Can we not strengthen them? There is a feeling amongst many people that, these tribunals are not doing good work. I'm not very sure about that. Maybe some tribunals may not be doing as good work as one would expect, but by and large, I think they're doing a pretty good job. Excise, customs, income tax, National Green Tribunals, Central Administrative Tribunal, Consumer Commission, all these bodies need to be strengthened. So really there's a huge resource that we have, and we need to, get that resource together so that we can move forward. The second thing that I would just like to briefly touch upon is technology and some changes that can be brought about. We have online courts. That is how the Supreme Court is functioning at the moment. But obviously it cannot function like this forever. Open hearings will be required at some point of time, but this is, I think, only a stopgap arrangement because of the present crisis. There are a couple of high courts. Delhi High Court is doing a pretty good job. Bombay High Court is doing a pretty good job. I don't know about Punjab, Haryana, but yes, we have online courts that are functioning. They have advantages. You can use audiovisual technology for making presentations of the submissions through PowerPoint presentations or through videos. That can also be utilized. Then you have virtual courts, which at the present moment is dealing only with traffic challans. They have one in Punjab, Haryana, under the jurisdiction of Punjab, Haryana High Court, Delhi High Court, Bombay High Court, and Madras High Court. I think that can reduce a lot of footfalls, into the courts, so that thousands of people who come every day to pay traffic challans need not do so. That can be upscaled. So there are a lot of compoundable offenses under municipal laws, under local laws, even under the IPC. All of them can be resolved through these virtual courts. Then you have, things like case management. Technology can be used for case management. We are not doing that, but we need to look at it. Paperless courts. Again, some courts are doing a pretty good job. Delhi High Court again comes to my mind. I think Punjab Haryana High Court had also started some paperless courts. I don't know what the progress is today, but this is again, technological advancement. Written submissions. Can we look at written submissions? The submissions being more dependent upon written submissions than upon oral submissions. I can tell you my experience in the Fiji Supreme Court is that wonderful written submissions are presented. Wonderful written submissions are presented, which reduces, the time for oral submissions. Time is given to each party of 40 minutes for making oral submissions, but they normally finish in about 25-30 minutes, and definitely within 40 minutes. Why? Because the written submissions are concise, to the point, and they cover every aspect. So the judges go through those written submissions and then attend court. Audio recording, why can't we use, audio recording as a means for, understanding what are the submissions that are being made instead of having to take down notes time and time again. There is discussion about live streaming. I don't know how far it's going to go, because the judgment was passed by the Supreme Court 19 months ago, and nothing has happened. But audio recording does not require any fancy technology. So I think that is one area that we can look at. The future, I think we have to be realistic, and we have to realize that social distancing and physical distancing are here to stay. Whether we like it or not, COVID-19 is going to be with us for a long, long time until a vaccine is found. And the papers and the TV suggest that it may take another year or so. But whatever it is, I think social and physical distancing appear to be here to stay. There will also be, a limit to how much judges can work. Suddenly you'll have a huge amount of filing once the lockdown is lifted. How many of those cases can be taken up? And how many people can actually visit the courts to argue and to hear their submissions of their lawyers? So with all these constraints, I think, I may be wrong, I think that the number of cases that will be listed in the courts will be much less than what they were prior to the lockdown. So in January, supposing in a particular court you had 60 cases listed, I would assume that after the lockdown is lifted and the courts start regular functioning, you'll probably have 30 cases listed. So the pendency is going to keep mounting up. There will be a huge amount of filing. There will not be that much of disposal. How do you tackle that problem? I think this is an area that is going to cause a lot of consternation amongst lawyers and litigants. So it's an artificial kind of reduction in workload. Not that the number of cases will be less, but the number of hearings will be less, or the number of listings will be less. Process re-engineering. Should we not look at the processes that we are adopting in our courts? Most of these, the civil code manual, criminal code manual, they were all, from the pre-independence time. Punjab Haryana High Court has followed the Lahore High Court rules. Now, come on, Lahore High Court is a different place altogether. Why can't we update our processes? Why can't we use technology to update our processes or make our processes in conformity with technology? There's so many areas in which all this can be taken care of, and we need to have this process engineering. Finally, for the future, I think we need to look at the court manager system very, very carefully. Judges, according to me, should not waste their time in committees. Liveries committee, library committee, this committee, that committee. Why can't it be taken care of by court managers? Why can't it be taken care of by administrative staff, so that the judges are doing nothing but court work or judicial work, rather than spending time on miscellaneous things? So I think it's a huge package that we need to look at. I will just repeat very briefly. Harnessing our resources, looking at technology for development, and the future. What are the changes that we need to bring about? This is all that I have to say for the time being. Thank you very much. Now, Vikas, because my screen is frozen, I think I'll just leave the meeting for a minute. And
yes, and the fact that we were not able to see you, but still the people were glued, shows the popularity amongst everyone.
Yeah, so I'll just leave the meeting for a minute and rejoin.
Yes, sir. And before you leave, I will just tell you the figures. Right now, we are though live on YouTube. As on a time, we are 950 on the Facebook and on this platform. Over to you, Justice Muralidhar. Welcome to you. And though that the day we welcomed you, we have not been able to appear before you in the High Court, but it's another platform where the lawyers of Punjab and Haryana High Court would come to know the different facets, and your knowledge will go streaming just like we are streaming on the YouTube. Over to you, sir.
Okay. I hope I'm audible to all of you.
Yes, sir.
Okay. Thank you, Vikas, and thank you, Dr. Gupta. It's always a pleasure to appear at any platform along with Justice Madan LOKUR, from whom I've learned so much when he was my senior colleague at the Delhi High Court. And the learning never stops. Like even today, his presentation threw up a lot of ideas. I don't know whether I'll be able to respond to all of them. I'll try and share some of my thoughts with all of you. I must say that this is the first time I'm appearing on a webinar platform. I didn't quite know, realize that the participation would be so huge. On the topic of judicial reforms, there have been a plethora of studies, reports by experts, both within the country and outside. And in fact, this is a topic which is as ancient as the system that we inherited, the Anglo-Saxon model. I go back to the year 1793, when Lord Cornwallis introduced the first set of judicial reforms, and that was known as the Cornwallis Code. And some of the aspects he was talking about, even in 1793, about huge pendency of cases, not enough judges, seems to bother us even now. We've had a recent spate of studies on the Indian judicial system by multilateral institutions, including the Asian Development Bank, the World Bank, the UN bodies, and of course, the Law Commission of India has been periodically studying the aspect of judicial reforms. The last of its reports is the 230th report submitted in 2009. One finds a commonality in the approach of the multilateral investment banks, and their concern was to improve the efficiency of the Indian judicial system to aid economic development.
Yes, sir.
And this explains some of the changes we've seen in, for instance, the arbitration law, the enactment of the Insolvency and Bankruptcy Code, and the new set of institutions, that is the commercial courts. We saw how the minute we enacted legislation to bring in the commercial courts, the ease of doing business ranking of India improved. So there is a realization that judicial reforms is absolutely crucial. But there has been a recent change in the approach of improving efficiencies of the judiciaries around the world. For instance, I found very recently, there is a report brought out in 2018 by an international consortium comprising 4 major institutions: the Australasian Institute of Judicial Administration, the Federal Judicial Center in the US, the National Center for State Courts, also based in the US, and the State Courts of Singapore. These 4 institutions formed this international consortium, which in 2012 drew up what is known as the International Framework for Court Excellence. I'm mentioning this in particular because of the changed approach to evaluating the functioning of judiciaries around the world. From an earlier institution-centric approach, they are now moved on to a freedom-centered access to justice approach, where the user satisfaction is of prime importance. In 2018, they've brought out a very interesting report, which is titled Global Measures of Court Performance. And I would urge all participants here to go online and look at this very, very detailed report. What this report does is aligns what are called core measures of court performance with core court values. These core court values were set out in the 2012 international framework. I would like to list out those values because those are equally important for any judiciary at any level, whether it's the magistrate's court or the Supreme Court. The core court values they talk of: the first is equality, the second is fairness, the third is impartiality, fourth is independence, fifth is competence, sixth is integrity, seventh is transparency, eighth is accessibility, 9 is timeliness, and 10 is certainty. And the 11 core measures of court performance, which align with these core court values, are very interesting, and they reflect the changed approach to evaluating judicial performance. The first and foremost in these core measures is court user satisfaction, which puts the user of the system at the center. Second is access fees. That is, how much court fees do you charge in civil cases? 3, the case clearance rate. You would have heard many discussions on the rate at which we dispose of cases. How many cases are instituted at the beginning of a year? How many at the end of the year? This is the case clearance rate. On-time case processing. Now, this on-time case processing really means that you fix a time cycle for a certain type of case. Let's say it's a CBI criminal case, which has 80 witnesses on an average, and it may be an offense under the Prevention of Corruption Act. You will look at the best performers and the worst performers and arrive at an average. So for each type of case, you devise what is called a time cycle, a life cycle for that kind of case. And this on-time case processing tests whether those types of cases have been processed within the time fixed for it, or it has exceeded that time. Duration of pre-trial custody, which is a very, very important core measure, because this tells you for how soon can you expect the trial in a criminal case to get over. I found this to be very interesting. Court file integrity, and Justice LOKUR has engaged in this aspect for quite a bit, even in the Delhi High Court. How easily is a court file accessible, not just to the judge or to the registry, but to the lawyer and the litigant? Case backlog. Do we have an accurate statistic on case backlog? The 8th core measure is trial date certainty. Like, we would like the trial to commence at a certain time. For instance, if you look at the Commercial Courts Act, you now have case management hearings, which purportedly fix the time within which the case will actually get heard and disposed of. Are we able to stick to those time schedules? Can we be certain about a trial date? 9th core measure is employee engagement. This is very interesting again. I think that for the first time, these are all parameters that are coming into this aspect of reviewing the performance of a judiciary. What we mean by employee engagement is how committed are employees in a court. Typically, your court master, your LMED, your peon, I mean, are all of them working with one goal in mind, which is improving efficiency of the judiciary and catering to the needs of the user of the system. Compliance with court orders is a 11th core measure. You will notice that both in the Supreme Court and in all our high courts, there is a contempt jurisdiction, and a large number of contempt petitions are filed. A contempt petition, in my view, is a measure of how efficiently are our court orders able to be implemented. And for many litigants, this is a matter of deep frustration that they're unable to get their orders implemented in good time. So this is another core measure that evaluates the functioning of the judiciary. The last core measure is, of course, cost per case. I'm mentioning these things only to highlight that there is a changed approach now to evaluating judicial performance world over. And even in our country, we've had now not just the government bodies or the Law Commission, but even certain private organizations like Daksh, for instance, in the South, or Vidhi, which have brought out reports on the functioning of the judiciary by gathering data, analyzing data. And this is an ongoing process. I highlighted some of these, not with the view that all of them may be relevant for us, but some of them certainly will. And we certainly can't have one size fits all kind of approach to judicial reforms. There will have to be regional variations depending on the needs of a particular institution. Just to go back to this central point I want to make is the approach to judicial reforms cannot afford to be only institution-centric. While I completely agree that the ADR and Lok Adalats are definitely tools that we use to ease the burden of the courts, we must realize that that also is a form of an institution-centric approach, because we do in Lok Adalats persuade people to settle for less. And the selling point there, of course, to the litigant is that his waiting time in court is reduced, and there is a certainty about the verdict, about the outcome. So these are points typically in a motor vehicle accident case, when somebody has, let's say, applied for compensation for 10 lakhs. At the end of 10 years, he's persuaded at the Lok Adalat to accept 5 lakhs as a settlement of the complete claim. So it may not be complete justice in the true sense of the word, but it's a pragmatic approach given the fact that we have a justice system that is unable to deliver verdicts in good time. The modern day approach, of course, is to treat the notion of justice as a broad-based one. It's not merely about institutions of justice delivery doing justice, but actually delivering or securing justice, which brings back the point of, for instance, implementation of court orders. So the approach now is to evaluate a judicial system. And here, when I say judicial system, it's not confined to the formal judicial system, which will include, of course, courts, the institutions of legal aid, like the legal services authorities. It might even include the mediation centers, which are monitored by the courts as in our system. But it will also include the non-formal legal systems, which are very vibrant and active in our country. And there are studies now afoot to see how far we can integrate, because our experience of the last 70 years of an independent India is that the non-formal systems have coexisted with the formal systems. And there may not be enough of a dialogue between the two to see which elements of the non-formal system still be incorporated to the formal system, if at all, and which, of course, will be unacceptable within a constitutional framework. So these are the broad points I wanted to make. And one question we need to ask is, do institutions of justice delivery provide efficient and effective services that are accessible and responsive to the needs of the people? For instance, how are vulnerable groups treated within the system? And these vulnerable groups would include minorities, children in conflict with the law, refugees and stateless persons, the mentally ill, the victims of crime, the internally displaced. I'm just mentioning some of these vulnerable groups because they are also brought into the system, and many of them not out of choice. They are out of circumstance of the way they are placed. Like a child in conflict with the law does not choose to go to a juvenile justice board. He's brought before the juvenile justice board, and he's treated within the criminal law context. So there are many such contexts in which the vulnerable groups, although they would like to stay outside the judicial system, nevertheless find themselves within the judicial system. And how do we treat them with dignity and secure to each of them the justice that they deserve? So this is one question that will be very predominant when we talk of judicial reforms. In the context of the Indian judiciary, whatever experience I've had as a judge of the Delhi High Court, I find two major sources of a feedback. One is, of course, the lawyers. And I know for a fact, and there'll be nobody in this today who will disagree, at least the ones listening in, that without the cooperation of lawyers, no well-intentioned step of judicial reform can actually go forward. And this, we've learned it in all levels of courts, that the lawyers have to be not only participants, but they have to be also cooperating and ensuring that this reform measure goes forward. I'll just highlight the question of the issue of family courts. You will remember that although we had a Family Courts Act way back in 1985, it was almost 20 years before lawyers agreed that we could have family courts. At least in Delhi, that was the experience, that it took several years for family courts actually to be constituted, because the lawyers still then did not feel confident that the system would actually be better for the litigant. And they were not sure what their role in that whole setup would be. So I think taking lawyers on board at every level is absolutely essential. I completely agree with Justice LOKUR about the need to look at some of the new measures that we've adopted, the tools we've adopted in the time of COVID, where he's mentioned online courts. And there I would like to only add that there is a distinction between online dispute resolution, which you find in some of the e-commerce sites, where you're just sending your claim to a site and you're not necessarily heard. You have a written note of a claim and maybe some submissions, and there will be a mechanism at the other end which deals with it and just communicates to you the decision. Then you have online courts where you submit all that you have online to the court, where at the other end there are some judges examining your claim, and if they feel necessary, they may hear you orally and like Justice LOKUR was saying, fixed time limits on either side. Of course, this can't apply across the board, and technology will be an additional tool which we will use in extreme circumstances such as these. And I don't see it completely replacing court hearings yet. And we have to develop confidence that the system which we are proposing can actually deliver. And there are other issues of having state-of-the-art technology, investing resources in improving infrastructure. And therefore, the online hearings as of now can only be a stopgap measure. I'd like to end by only highlighting the importance of data gathering and analysis. Justice LOKUR must be credited with ensuring, when he was head of the E-Committee, the Supreme Court, the setting up of the National Judicial Data Grid, which is an extremely useful tool. And for the first time in this country, we're able to get fairly accurate, I wouldn't say completely accurate, fairly accurate statistics of the functioning of the subordinate courts in the country, district courts and below. And I don't think enough use has been made of this wonderful resource that we have. Not enough analysis has been made of the functioning of the subordinate courts using this data, which is it's capable of that kind of analysis. And there are active efforts now to bring the data of all the high courts also integrated on such a platform. Judicial education and training is another very, very important aspect, which we haven't learned to evaluate yet. We've got this national judicial academies, we have the state judicial academies, but there must be a process of auditing the outcomes, the functioning and outcomes of these academies. I think they've all been around for about 2 decades, some even 3 decades. And it's high time we ask ourselves whether there are certain aspects of both judicial education and training that require a relook and an improvement. Lastly, I would like to say that there must be a system of continuity. So even when we talk of judicial reforms, it should not end up in reinventing the wheel, that another set of reports, another set of studies are produced on what has already been done. It should be a build-up on what's done, and there should be an element of continuity so that these can actually be carried to the stage of implementation. With these thoughts of mine, I'd like to conclude my address at this stage, and thank you again for giving me this opportunity.
Thank you so much.
Sir, Gupta sir, Justice MADAN LOKUR is on video also. Sir, I will ask Justice LOKUR, people would like to hear you on that, and we will then immediately post the questions. I'm unmuting Justice LOKUR and Mr. Balram Gupta. Justice LOKUR. Yes, sir.
Yeah, I didn't get what you were saying.
Sir, I was saying that since we were not able to see you, though we were only mesmerized the way you were speaking, but everybody wanted to see you live.
Yeah, okay.
Meanwhile, 2 lines from you, and then we will take the questions. And again, I'm telling the participants, only questions in respect of judicial reforms be posted, please. Already we have flooded with the chats, regarding suggestions, etc., and questions on their opinions on certain judgments will not be taken up, lest they will say that they were not allowed to participate in the right perspective. Over to Justice LOKUR.
Yeah, okay. Thank you, Vikas. Now, you see, Justice S.MURALIDHAR has given a very broad overview of, various aspects of judicial reforms. Whether it is criminal justice, whether it is family courts, and so on and so forth. So what I think is important is that you can't look at judicial reforms as something which you can do overnight, or it may take maybe a few days or a few weeks or something. It's a long process which is going to require very consistent efforts on the part of everybody, whether it's lawyers, whether it's court staff, whether it is judges, whether it is litigants. Today, litigants have hardly any say in what is happening in the court, but they're perhaps the most important stakeholders, right? So it's a huge task, and I think all of us must, work towards those judicial reforms. We have to acknowledge the fact. I think we have to acknowledge the fact that we are facing very serious problems. The numbers are staggering. the time taken for disposal of cases, it can sometimes take a generation. So unless we all work together in whatever sector we like, or in all the sectors, unless we do that collectively, perhaps things will just drift. And then, 5 years later, we'll still be discussing this same sort of a thing. Yeah. So back to you.
Mr. Gupta.
Thank you, Vikas. The two presentations have really laid the roadmap for us in regard to the judicial reforms. I would like to take up one or two issues to begin with before we take up any questions as such. Justice Muralidhar has rightly spoken about the auditing of the judicial academies, including the National Judicial Academy, for the reason that they have been in for some time, and this particular role of the academies need to be reviewed and audited as such. And in this particular context further, the basic issue which has been raised by one of the participants in this particular dialogue is regarding the jurisdiction of the Supreme Court under Article 142. Interestingly, he uses, in fact, it is an advocate, Chirayu Jain from Delhi. And his version is that Article 142 of the Constitution has rendered the Supreme Court as a despotic institution. And should this particular power be not delegated to the high courts as such? This is one issue which I would pose to Justice Madan LOKUR. Secondly, along with this, Justice LOKUR has made a very significant point, reducing the time which is consumed in the hearings as such. And a particular reference has been made to the Fiji Supreme Court experience of Justice LOKUR in this particular context. A wholesome written submissions are submitted, which go a long way in adjudicating the matters, deciding the matters as such. Now, the Indian Supreme Court's time is consumed considerably in oral hearings as such. And therefore, this particular area needs a serious consideration. On the one hand, the best of constitutional jurisprudence in different domains has been produced. Through the oral hearings, the contribution which has been made by the lawyers and the judges in this particular context. It's evident from the records that we have over the 7 decades as such. Will the same kind of growth and development of jurisprudence, constitutional jurisprudence in particular, be possible if we restrict the oral hearings and only ration the time like the US Supreme Court, 40 minutes or 50 minutes or 1 hour or 30 minutes as such? Will that really lead to something which we look forward to? Over to Justice LOKUR, please.
Thank you, Professor Gupta. On the first issue about the interpretation of Article 142, on substantial justice, well, I think it's a matter of opinion, what the questionnaire has, that it is being used in a despotic manner. I'm not sure, I would go along with that opinion. But then, delegating that or giving a similar power like that to the high courts will also make the high courts despotic, so really giving that power to the high courts, does not really solve the problem. But primarily, I don't agree that it is being used in a despotic manner. The second question that you have raised about limiting time. Now, in many countries, I mean, of course, we know about the United States. In the Supreme Court, they give half an hour.
That's right.
It.
That's right.
you know, and you can file as many written submissions as you like. I mean, in the sense of interveners and so on. So they are fully prepared with the case. They read everything. I don't know if if some of you have heard the audio recordings of the hearings that have taken place in the Supreme Court last week. The judges are fully ready with the entire case. So are the lawyers, of course. So really, and by the way, in the American Supreme Court, they're dealing only with constitutional issues, and yet, for I don't know how many years they've been following this half an hour practice. So really, it can be thought about. It will take some time. It's not that again from tomorrow you tell all the lawyers that listen, you have to argue only for half an hour. It will not be accepted. But yes, this is something that we should think about. Let's not reject the idea completely. And I know that it's working pretty well. Of course, we don't have so many cases in Fiji, but whatever cases there are there, it is working very well. There's also an audio recording of whatever is happening in the court. I had asked somebody a question, one lawyer, and the Chief Justice told me, he said, "Can you speak louder?" So I was a little surprised. I said, "He can hear me." So he said, no, that he can hear you is all right. But whatever you're saying is also being recorded, So you have to speak loud enough so that, and into the microphone so that everything that you say is also being recorded. So the entire proceedings were audio recorded. Okay, so then a lawyer cannot get up, after 15 days or 20 days and say, "Listen, I argued this point, but that was not dealt with." The audio recording is there. So, these are things that we need to think about. That is the purpose really of today's, discussion. Yeah, thank you.
Yeah, thank you, Justice LOKUR. In fact, another question which one of the advocates, former Additional Advocate General Haryana, Lokesh Sinhal, is raising the issue connected with the regarding the live streaming of the court proceedings. As Justice LOKUR has rightly said, 19 months back, that particular judgment had laid down this aspect, and yet no positive steps have been taken in that particular context. How can we really make it workable in the present situation as also in the future once we are through with this particular crisis? Justice LOKUR.
Justice Madan Lokur. I'm unmuting Mr. Lokur.
Yeah.
Yes, sir.
Live streaming is a good idea, but there are a lot of, things that have to be looked into. For example, should it actually be live, or should there be a, time gap of maybe 1 minute or 2 minutes or something? Who will have access to it? The Canadian Supreme Court has a dedicated channel on television, right? So
yes.
So the arguments as they are being advanced, you can watch it on television, but they don't have that in the United Kingdom. Okay, so there are different ways and means of live streaming, and how do you actually manage it? That's the other thing. The Supreme Court will have to think about it, and like I said, 19 months ago they had passed this order. How they're going to implement it is really a challenge. But yeah, if live streaming can be done, nothing like it. Yeah, thank you.
Justice LOKUR, another particular issue which has been raised, which to my mind is very relevant, by Mr. Anuruddh Bhattacharya, an advocate from Calcutta. What he wants to say that how can we improve the quality of judges, judgments, and the disposal of cases in the court of first instance. Now, I'm posing this question because you have been closely associated with judicial education. Both you and Justice S.MURALIDHAR have been associated with us in judicial education for that matter. You are well aware as to what all is being done. At the National Judicial.
Professor Gupta, could you come to the center of the screen, because sometimes you're not visible fully. Yeah, that's better.
Is it? Thank you.
Slightly more.
Thank you.
Sir, slightly more towards the left side. Slightly
Is that right?
More. Slightly more, then you will come to the central point. Thank you, sir.
Is that right?
Yeah.
Thank you, Vikas. See, you know what all is being done at the National Judicial Academy. You also know the role which is being played by state judicial academies. And therefore, what is the roadmap for the future which you would suggest in this particular context?
Sir, Justice LOKUR, I will say, recommend, though there are certain aberrations when it is there, because since you would be answering, if you mute it, then the entire process will be slightly hampered. You can remain unmuted itself. Otherwise, the question answer session will be different. Yes, sir.
I think let Justice MURALIDHAR take that question.
Yes.
Point of view of judicial education.
What we do in the judicial academies, we do have sessions on judgment writing. But like I said, they come for that session and go back, and I don't know to what extent those sessions have been useful to the trainee judges. So this is something we haven't really understood. The second is the issue of language. We are talking of courts at the first instance, so I presume we're talking of local courts, and there is a huge variation in standards. I mean, I completely agree with the questioner that this is a huge challenge before us, because there are people in India who think in their mother tongue and try and translate that into English. And although the law texts and the teaching of law is essentially in English, it is still not easy for people to immediately get to legal language and for expressions, and even marshalling facts, analyzing the facts, and to do all that in understandable, clear English. So I think we need to give English language training along with legal language training to a whole host of judges. Many of the judges are probably writing. I think in states of Uttar Pradesh, for instance, they may be writing those judgments in Hindi. So I think we need to get language experts too at that stage, so that judgments are not prolix and judgments are to the point. And this is an ongoing process where the training has to be, I think, far more rigorous in the initial stage where they're doing their probation. That's why I said we needed to audit those systems. I think this is still continuing to be a challenge before all of us. We must also realize that the tools available to those judges at that level are not what would we imagine that judges in the High Court or the Supreme Court have. Many of them don't have proper stenographers. Some of them are still writing orders by hand. So these are also other issues. The third and, of course, foremost issue is caseload itself. Even at the level of the Supreme Court, on a Monday or a Friday, you have a bench of 2 judges dealing with 60+ matters, which is something unheard of anywhere in the rest of the world, where the topmost court, the highest court, will have to deal with that caseload. Now, at the level of the munsifs or the magistrates or the first level of junior civil judges, the caseload is still very high. And we need to acknowledge that when we insist that we should have good quality judgments. How can we ensure that a judge is not forced to deal with more than what he or she can handle? Because the minute your caseload goes up, the quality of your judgment falls. I can say out of personal experience as a High Court judge that the days I have 80 and 90 cases listed before me, my concern is how do I get past that whole list? How do I complete even one calling of that entire list? And it does affect my efficiency, it does affect my concentration, it does affect my performance. So this is some balance we have to strike between the caseloads we are subjecting judges to and the quality we expect them to deliver. So I don't know if Justice LOKUR would agree with me on that or not.
So I would just like to say that the way you are saying that these judges should be trained for the particular how they have to write the judgments. One concern amongst the legal fraternity is that the lawyers also intend that what are the nitty-gritties of pleadings, how to search law. Though during these lockdown period, one thing which I've learned during all these webinars, though we are also been conducting webinars continuously, today's around 37th webinar of ours, to the effect that in fact certain webinars are there that fundamental basics of pleading, fundamental basics of searching law. There are certain webinars, certain universities have taken initiative. I think if we all work on that modules, including our platform, etc., or any other platform where we can take into how the pleadings, etc., should be done, so that once the lawyer doesn't put the or hammer the point in the right perspective, it will not be, the judgment will not come. It is more like a computer. What comes in comes out. So the input from the bar is also required. That is why they say bar and bench are two wheels of the same vehicle to flow to go better in a better way. What is your take, Justice LOKUR?
Yeah, you see, I agree with you. You have to make a distinction between legal education and judicial education. Now, what Justice Murali is about judicial education. Of course, a huge amount of reform is necessary, and as he said, there must be an audit of all this. You see, writing judgments is one aspect, but there has to be some behavioral change or a behavioral awareness. Now, there are biases that people have, hidden biases. There may be a gender bias, or there may be a pro-rich bias or a pro-poor bias or something like that, a pro-landlord, pro-tenant, pro-capital, pro-labor. So I think judicial education has to take that into consideration. That's a separate aspect. So far as legal education is concerned, there is a lot of reform that is necessary. And I think the universities, it is their responsibility, to tell the students how to draft pleadings. It's not enough to know all the case law. There is much more to, court cases than what is there written in the books, right? So I think it is a responsibility of the universities. Second, in some of the countries, they have continuing education for lawyers, which is to say that after 5 years or after 10 years having joined the bar, you have to take another examination so that your license gets renewed. Not that once you get a license, it's there for life. It's not like that, So maybe the Bar Council of India, maybe the bar associations or the bar councils can have a look at that. Should there be a sort of a test after say 5 years to see whether the lawyer is keeping up to date, because new laws are being passed, specialized laws are being passed. Things are changing. Law is developing, practice is changing. Sure, I think that's a very important aspect of, reforms. Yeah, that can be looked at, certainly.
So, fortuitously enough, we have Shruti Bedi, who is a daughter of Mr. Balram Gupta, and she's a professor. Once we say that the university also has to take a call, I will just unmute Shruti Bedi so that she can give the input. What does she want? Dr. Shruti Bedi. So meanwhile, I will read one question. Jit Lali says, "Sir, how do we need to amend our procedure codes to make it more litigant friendly? For example, in some countries, the pleadings are exchanged among lawyers and then they frame issues, if any, between them. And then the case is put forward to the court to decide. Here, the pleadings are exchanged before the court and evidence. What is the way forward?" Hello. Yeah. So Shruti is not being unmuted. Meanwhile, Justice Muralidhar or Justice LOKUR can.
Yeah, Justice Muralidhar.
Hello.
Actually, when Justice LOKUR mentioned this process re-engineering, in fact, we were a committee of 4 or 5 judges of the Delhi High Court, and Justice LOKUR was steering us. And we were re-looking at all the rules of practice and rules of procedure to actually make it citizen friendly, so that you don't have so many applications and so many steps in a particular case. And we were doing it jurisdiction wise, civil, criminal, and even within civil, different kinds of matters. Now, Justice LOKUR said this is an ongoing exercise. This has to be a continued exercise. For some reason, that exercise was discontinued because it did not get the right kind of support it needed. But at a central level, and maybe at even state levels, if simultaneously these exercises can start at the level of the high courts, preferably, and they start re-looking at the rules of procedure, some of the antiquated old rules of procedure and forms that we use, forms of address, the terms that we use, these can all be simplified. In England, you have a system where when you draft a law, the draft bill is actually circulated amongst 5 lay people to get their feedback on whether they can understand what the law says. And it is so essential for us in this country particularly to do this. And even lawyers, even judges sometimes find it very difficult to decipher what a particular amendment intended to do, and the terminology can be very confusing, it can be inconsistent. So this is an ongoing process. I would completely agree that rules have to be citizen friendly, and we are already late in doing this, I would consider. So I can't emphasize more the need to make this friendly to the litigant.
So before we take questions, one fact which is boggling, the judicial part we will continue to do. One fact, since you are at the helm of the affairs in the Punjab Haryana High Court and Justice LOKUR has given fantastic inputs on all the aspects. So how do every lawyer is bothered, how do we go in the virtual platform during this era? What are we going ahead with the procedure? Because certain people feel that this online filing, etc., is slightly tedious. How it can be more expeditious, or where we can give inputs, the lawyers want to give inputs so that the system could be facilitated. Some online procedure wherein suggestions can be given that the committee can look into it, because all lawyers, it is not always that too many cooks spoil the broth. Sometimes many cooks also make a good feast.
Yeah, Justice LOKUR, please. Yeah, I think he should.
Yeah, you see, the e-filing procedure is already available in the district courts, right? Only thing is, the district court lawyers have not used it, but you can find the you can do e-filing if you go to the e-courts website. There is also a manual, on how to do the e-filing. Now that manual has been prepared by a lawyer, Dr. Karnika Seth in Delhi, pro bono. She hasn't charged anything for it, and she has prepared a manual. Now, I know in Tamil Nadu, there is a judicial officer who is, through the Judicial Academy, training lawyers and training judges on how to use the e-filing procedure. So these are things which are already available, right? Now, if there is some problem in in the e-filing procedure, the e-committee can always be approached, or if there is some error or something, or lack of clarity in the e-filing manual, that can also be brought to the notice of the e-committee so that necessary steps can be taken. So we have all these resources, but we are not using them, number one. Number two, training people to use them is also not a problem. Like I said, it is being done in Tamil Nadu. When video conferencing was being utilized, some of the prosecutors, they said, we're having a problem on how to use a video conferencing unit. Some of the jail staff said we have a problem. So through this, Bureau of Police Research and Development, BPR&D, and the National Police Academy, programs were conducted for judicial officers, for public prosecutors, for jail staff on how to use the video conferencing unit. And they were trained, and they had to go back to their respective states, coordinate with the judicial academies, and carry out the training. So these are not complicated affairs, and many of them are user friendly. There may be some complications once in a while. One can't rule it out. But yes, if there is a complication, it can be resolved. So training is easy. The tools are available. We have to utilize those tools. That's it.
So since we have a pleasure that we have Justice Muralidhar, the point what you have taken is, I think it's well taken, that some people are actually not well versed with the tools. If we can have a small video on the procedure, I can ask the participants also if anybody can, just like what you said, Kanika Singh did a fantastic job. So we can ask somebody to prepare a video how to do the e-filing, especially during these times, so that large number of people are not able to connect it. Some large number of people have certain doubts how to do the e-filing. A small video or small instructional manual, if it is available, it becomes very, very easy, because the fact that the way it is being going on, the lawyers as such feel there are handicaps.
Yeah.
And Shruti Bedi joined.
Can I just add here to?
Yes, sir. Yes, sir.
No, so the point really is we have to run pilots, I feel, to get a feedback from the lawyers on how easy it is for them to do the e-filing. See, in the Delhi High Court, when we did permit e-filing, but not online filing. I think there is a distinction to be made between the two. Online filing is that you file from wherever you are, from your chamber, or from another city, or from your house. You just upload the file onto the court system. Whereas the e-filing that we had in Delhi High Court was that we provided kiosks in the court building itself, and the lawyers could come and e-file the case. And we had it in 3 jurisdictions, which was tax, arbitration, and company jurisdictions. And that was quite successful. When it comes to the online filing, I think what we need to do is understand certain issues. One would be of the connectivity issue itself. Is the same level of connectivity available across a whole region? Let's say Punjab or whole of Haryana. Does it mean a lawyer sitting wherever can simply upload? Then the size of the file. Let's say he's uploading a 5 MB file or something larger. Is it able to be uploaded? Is the system ready to receive it? And there are these nitty-gritties of affidavit and attested affidavit. So we tried to address some of these issues when we devised an e-filing system in the Delhi High Court. So what I'm saying is,
sir, sorry, Justice Muralidhar, could you repeat the last 2 lines, because somehow we were not you were not audible.
Yeah, no, what I'm saying is we tried to address some of these issues of affidavits, attestation, filing of originals, some of these issues, or even countersigning a document during admission denial. These are nitty-gritty issues which we can address if we actually test the system by a pilot and run it across lawyers. We'll get a feedback from lawyers. They'll be able to tell us where exactly they find problems, and we can then address that. The second issue on online filing would also be about limitation. When we have had online tenders, we've had a large number of cases in the high courts, and a large meaning a substantial number, where somebody says, I tried uploading my documents from 10 in the morning, and the closing time was 2 p.m. and I could not do it. And he then produces logs to show that he could not do it. So we will have to account for the failures of our networks and see how we deal with that. So the basic point I'm making is, whatever system we have now devised, we should test it, run it across lawyers, and then probably improve it before we launch.
So thank you. But the only issue is that e-filing, yes, we were doing it. But the only difficulty which the lawyers, at least in Punjab and High Court, is doing, since yesterday we had posted that you should give the judicial reform, large number of lawyers are pitching in the messages on my chat box to state therein that there should be some video, or there should be somewhere we can pinpoint that these are the difficulties, and person out in the High Court could just work out the modalities. And Justice LOKUR is pitching in some opinions on his. Over to Justice LOKUR. Yes, sir.
Vikas and Justice Muralidhar, since the e-filing procedure is available on the e-court's website, would you like to try and consider having the pilot in Chandigarh itself?
We can
try it out. The manual is there. Videos are there, by the way. Videos are also there. Manual is also there.
No, we should
try out the pilot which Justice Muralidhar is suggesting, and let Chandigarh take the lead.
Right. So the only issue and the only difficulty is that everybody was trying to get assimilated with the e-filing, but nobody was actually prepared with this pandemic and the lockdown, etc. The entire system of filing, that you will have an OTP, and the OTP to the client, that actually, because there's no signature, the verification part is acceptable. But there are certain changes which have come down during the testing and the trying times, Only on that point, I'm saying let's say there be a video or there should be a catalog showing that what are the facilities. The
Try it
platform
out.
today is judicial reform.
Vikas, try it out in the district courts. Forget about the High Court for the time being. Try it out in the district court. Ready-made packages.
So people will run over. People will just run over me because they will say that you are doing primarily the High Court and you are not bothered about the High Court and you are on the platform saying that the judicial reforms how will go.
As a pilot.
So I can become a co-pilot and we will go ahead in that way. Shruti Bedi joined Mr. Balram Gupta's daughter. As we said that the students also have to be encouraged as to how we have to go for the pleadings, how to go for the drafting. I just wanted how they are going about with the UILS, since this webinars of ours is in partnership with UILS, and we have also Professor Ratan Singh. We will take him also on the board at one point of time. Shruti Bedi, what you are doing, Professor Shruti Bedi, what you are doing to encourage the people to do better research, and how do we encourage them to go for the virtual platforms?
Thank you, Vikas Chatraji. Honorable Justice LOKUR, Honorable Justice MURALIDHAR, such a pleasure to listen to you. And I would just like to say what I'm reminded of what Jeremy Bentham said once, that lawyers is the only species in whom ignorance of law is not punished. So taking a cue from that, we are trying to do our best for the students, and we are giving them a whole variety of platforms to develop their researching skills, which includes the alternate dispute resolution as well, including the moot court areas. But like you both suggested, that the students are not really equipped when they come to the law courts to really tackle the practicalities of the functioning of the court system. But a very big advantage that the new law student is able to give to the functioning of the law courts is technology and research now, something which they are very good with, and something now that we need to look into, especially in this kind of a situation. So probably a 1,000-page document being drafted by a lawyer and calling it a brief would not be something which would continue now in the future. So thank you so much for letting me hear to this extremely brilliant interaction between the judges and the hosts. And it's been an honor and a privilege to be a part of it. Thank you, sir.
Thank you, Shruti ma'am. Now we will take few questions from the chat, and some questions have come on the, that's my WhatsApp also. And with the leave of Justice MURALIDHAR and Justice LOKUR, I will say that though we invariably end up the session by it should end up at 1 o'clock, but the questions we have not taken. We will be taking few questions. We will have slightly extended session up till 1:15, because ultimately before we conclude, we will also like your inputs, how the lawyer should work upon. But first, we should clinch upon as to how the judicial reform should go on. Mr. I.P. Singh, who is the president of the DRT, he asks a question: for transparency, the tribunal should be brought under the Ministry of Law and Justice. It will minimize the interference of the concerned ministry. And what are the ways, how the execution, etc., even though there is a decree, how do we intend to do it better?
Yeah, well, as far as I am concerned, I have no view on that. Whether it should be under Ministry A or Ministry B or Ministry C. I have no view on that at all.
No, sir, the question is, yes. Yes,
yeah,
sir.
You can repeat the question. Sorry. Yeah.
So the question was, he says that once the tribunalization, let's assume for a DRT, it should be under the Ministry of Law, so that there is more independence, and there should be all more trained judges and the recovery officers, because invariably what is happening in the DRT is they are invariably the law officers who latch on the post of the recovery officers, and sometimes they are not well versed with the nitty-gritties of the execution proceedings. So once there is huge amount of money involved, more so during the lockdown period, do you feel that there should be training for these recovery officers before being appointed, or after that, just like we are having in the judicial academies, etc.? What is your take, Justice MURALIDHAR?
I can tell you in the context of the VAT recovery officers in Delhi, we in fact had to say in judicial, in certain judgments, that they must be given training in our judicial academies, because we found that the officers posted as assessment officers or even recovery officers were not well versed with the legal procedures, and even the basic norms of the requirement of natural justice, for instance, these were not being followed. and they didn't understand even the statute well enough. And we can't blame them, because somebody who's an education officer 2 months ago is today posted as an assessing officer under the sales tax law, and now it will be the GST regime. So there are these issues with tribunalization, where persons not trained in judicial functions are expected to discharge judicial and quasi-judicial functions. So while we look at the role of judicial academies, I think those have to be encompass training of several non-judicial, quasi-judicial officers. For instance, I know for a fact that in the judicial academies, training is given to members of the Child Welfare Committee and the Juvenile Justice Board members functioning under the juvenile law. So, and there are, I think, in batches, some of the tax revenue officials in the various states and even at the income tax department, they're also given some training in the judicial academies. But this needs to be systematized. I think it has to be expanded. If we are persisting with the model of tribunalization, which we appear to be, then for it to function effectively, and in fact, this has been a demand for a long period, that all of this should be unified under one ministry, namely the law ministry, so that the terms and conditions of service of members of such tribunals is uniform, their functioning pattern is uniform, they have a common training. In England, I think that's where we need to look at. In UK, they have unified the functioning of all tribunals into one body. And that is itself in charge of the funding of the tribunals, the training of the personnel, the staffing, all of it. So if tribunals has come here to stay, because there's been a lot of criticism of functioning of tribunals in several judgments of the Supreme Court, but it seems to have no impact because governments of the day persist with tribunals. So if tribunals are here to stay, then we need to seriously think about training of all tribunal personnel and also officers down the line who feed work into the tribunal.
So we are lucky enough.
Vikas, can I add?
Who is on the Judicial Academy. Sir, I am adding that only. We have Professor Balram Gupta, who is the Director of Judicial Academy Administration. We would like to have his inputs, and more so once you are on the platform. How do we take about with this suggestion? Over to you, Professor Balram Gupta.
I totally agree with Justice Muralidhar that it needs to be unified. The entire system of tribunals needs to be unified under a particular law ministry as such. And then the training programs need to be scheduled and organized in an organized manner. At the National Judicial Academy, during the time that I was there, we had regular training programs for the Central Administrative Tribunal, non-judicial members in particular as such. We are having programs for the consumer courts, even at the Chandigarh Judicial Academy. And therefore, the judicial academies can be utilized effectively in order to train particularly the non-judicial members. I have my own experience at the bar before the tribunals as such. The non-judicial members need to be trained properly, effectively in the entire system for that matter, if we wish the tribunals to play an effective role. Thank you, Vikas.
Thank you, sir. Your inputs have also. Justice Madan LOKUR wants to pitch in his.
Vikas, one of the things that was raised at the question was about training of recovery officers, right? Now,
yes.
According to me, everybody has to be trained, right? Whether they're recovery officers or not, everybody has to be trained. I'll give you one example. In the district courts in Delhi, service of notice or service of summons was ranging between 20% to 30%. Through the Delhi Judicial Academy, we had the training of process servers, right? And after the training was over and a little bit of reorganizing and restructuring, it went up to 80%, between 80 and 90%. That's the value of training, so there is no doubt that training must be given at all levels.
So point well taken. That's what I said, that today we have the two speakers, both whose name starts with M, and that is why we call both the magical minds are with us. MM stands for magical minds. We'll definitely have good inputs and good insights. Rather, we can also have these judicial academies, certain lectures They can also have certain lectures which are for the common man. They can also come on the YouTube. Anybody whosoever wants it, it can be watched. That is my personal take. Justice LOKUR or anybody in that committee can take into consideration. Let's assume that any act there has been this thing. We can always have that video. Anybody can just peep into it and look into it, and his insights can be improved. Justice Muralidhar, can we have your inputs on that point?
No, come again. You're not clear. Somehow breaking.
Sir, I was saying, like there are judicial academies, they are having different courses and different sessions and different, as on date, webinars also. After the webinars are over, and which you feel that anybody could actually get his knowledge enhanced because of those webinars or that meeting, those can be uploaded on the YouTube channel of the Judicial Academy. Anybody can watch it so that he can also increase his knowledge.
Absolutely.
Like Justice LOKUR said that they enhance the knowledge of the process server. So why not that knowledge which was imparted in Delhi Judicial Academy, why not be it open to everybody in India, whosoever wants it? The word spreads like fire. Like we have seen, we are a testimony of this beyond Law CLC. We came out during the lockdown period and people are watching. Today we were touching around 1,000. We were just fearing that we had a platform of more than 1,000, but it touched around 980, and then we are on live on the Facebook, live on the YouTube. So I will just ask Punita Sethi, as president, she has been former vice president of the bar. She says, that's on my WhatsApp, that's not on the chat. Earlier, there was a requisite mandatory minimum experience of practice for entering the judiciary. What is your take? Does it improve the results in the judgments or not? Hello?
Yeah. You want me to answer it?
Justice LOKUR, Justice Muralidhar, are you able to hear me?
Yeah, sure. Let Justice LOKUR go first. I'll come.
Okay, yes, my view is that there should be maybe a period of 1 or 2 years, maybe 3 years on the outside before a person gets qualified to become a judge or sit for the examinations to become a judge. You see, today what is happening is in many places, a person does law, does not enter into a courtroom, just studies and passes the judicial services examination and becomes a judge without having any practical experience. I think that practical experience is necessary. That is my view before induction into the judiciary. Yeah, Justice Muralidhar?
Yeah, I think I tend to agree with Justice LOKUR on this because, in the Delhi Judicial Service, they're having judges as young as 23 years old. And they've really not had any exposure to the bar. And I must say that, to tackle the bar in some of the jurisdictions which they hold, they would need, some exposure to the practices of the bar and how to tackle lawyers. And knowing and understanding the court system is absolutely essential before you become a judge.
Since Vikas, I also wish to add to that.
Yes, sir. Yes, sir.
There can't be two opinions that the exposure of the bar, maybe short 2-3 years exposure, would do good before they may assume the role of a judge. But my own experience and dealing with the young judicial officers has been that when they join the bar, they actually do not go to the courts. They spend that particular time preparing for the judicial service examinations and the required exposure which they need to have, which is a real asset for working as judges, they do not get it. And therefore, we need to ensure that the experience at the bar is actually carried out. Thank you, Vikas.
Thank you. So another question, like the Chief Justice of India is time and again saying, the role of artificial intelligence has to be improved. And on virtual platform, Justice LOKUR's articles have been well read and well received amongst the social media, plus those who have read it actually on the paper. So what are your take on the artificial intelligence and the virtual platforms in the coming days? First, I will ask Justice MADAN LOKUR, and then I will ask Justice Muralidhar what is his point of view on that point?
Yeah, you see, so far as artificial intelligence is concerned, I really don't know what the Chief Justice has in mind. What is the artificial intelligence going to be used for? Is it going to be used for improving the functioning of the registry? Is it going to be used for I don't know, for writing judgments? I don't think a machine can write judgments. What is it going to be used for? I'm not very clear on that, so therefore it's very difficult to react to what he has in mind. You see, artificial intelligence as such has not really been used in any court in any part of the world, particularly for judgment writing and all that. Research, yes, you do have a very large number of, data banks and all that. Frankly, I don't know what he has in mind, so it's very difficult for me to comment on that.
The artificial intelligence, as Justice LOKUR is saying, for the purposes of searching law, etc., yes, definitely the time when we entered the profession was entirely different of searching law on the books, etc. With the help of the aids and the tools, etc., it has become easy. I will just ask Justice Muralidhar, what is his take on the artificial intelligence and how do we go ahead?
Yeah, you see, I think I'd agree with Justice LOKUR. While this term artificial intelligence itself requires further elucidation. For instance, an algorithm which analyzes data is also a form of artificial intelligence. So if you're looking at a data bank and asking the question, how many Section 302 cases are pending in this court where a prisoner is in jail for more than 5 years, that kind of a question, if you get an answer immediately, well, that's one use of this algorithm. So what use we put it to is going to be the most critical thing. And I think studies abroad have shown that there are limitations to use of artificial intelligence. For instance, when they had to find out in a particular court in the US, how many people had jumped bail and had not reported back after the expiry of the bail term, the artificial intelligence actually made a mistake. Let's say there were 2 Ramesh Kumars. It went and picked up the wrong Ramesh Kumar. And the man had actually served his entire sentence and had been employed somewhere usefully. And because of this mistake of artificial intelligence, they went and picked him up again and again put him back into jail. So there can be serious errors of artificial intelligence if we are not absolutely sure of its working and the kind of data we feed. Like, look at the other systems we have around us. There are so many errors of the computer, the wrong spelling, the wrong date of birth, the wrong parentage, even your voter identity cards. These are all supposed to be computer enabled systems which are supposed to be helping people to easily identify and take decisions. Even here we have numerous problems. So I think we are still at a very nascent stage. We need to be clear what we mean by artificial intelligence, and again, we'll have to come up with a system that is really foolproof before we can try it.
So in the lighter vein, they say that the artificial intelligence and intelligence have to be combined together, because autocorrect is also sometimes dangerous. Like in our courts, one joke which goes around is on the corner is that there was a Prevention of Corruption Act case going on. So he had written that I had given him bribe and he accepted it happily. And it was typed, I had given him the bribe and he accepted happily. Then they said, once he's a son-in-law, why is the conviction required? So artificial intelligence and intelligence have to be correlated together. So we have Professor Ratan Singh again from UILS. He would also like to have an input from him as to how we go about these studies, etc., to make the bar more stronger during the coming times.
Yeah. Thank you, Vikasji. Thank you, Vikasji. It's really an honor and my privilege to interact in the presence of Honorable Mr. Justice MADAN LOKUR and Honorable Mr. Justice MURALIDHAR. So, being a student of law in the university, what I feel is that when you talk about bar, you talk about training, you talk about judicial education or the legal education. What I feel is there are the different wings and different parameters, like the different duties on the legal education institutions, and then the duty shifted to the judicial institutions like judicial academies. And once the judicial academies, they train the student in a such a way, then once they go in the field, they learn accordingly. So it means the one parameter where we are to give and impart legal education are the legal educational institutions, then judicial academies, and then the real profession. And that too, bar council have to play the role in such a way that the subject which they are introducing right in the curriculum of this for the students and for the different educational institutions, probably these should be of the subjects which are latest, which are really touching to the practical orientations. And being here in the University Institute of Legal Studies, as Professor Shruti has already referred, that we are training the students and in a such a way that they are drafting not only the pleadings, right, we are training them to draft the legislations also. So nowadays, the students coming after the +2 and they join the profession for 5 years, and for the 5 years they are trained so that immediately after completing their degree of 5 years, they start the practice and well aware about the technicalities. And I suppose the 5-year course and the institutions nowadays, like our institution or the national law universities, they are doing very good. And probably the roadmap and the suggestions which Lordships has given, probably these need to be taken care of in future too also. Thank you, Vikasji.
Thank you, sir. So Mr. Saurav Khurana, who has been the former secretary of the bar, he says that the scanned files at one point of time were being easily available for anybody. So right now we are only having files, let's assume what the petitioner has filed. The entire file, just the, like the judges have the written statement, the application along with pagination. During this time of social distancing, why don't we make it more accessible and at least the ordinary cases, let's assume the urgent filing is having some difficulties. This is what messages I have received. We are having difficulties over the urgent filings. The ordinary files, the lawyers generally have the hard copies with them. The soft copies can be made available to them. And at least we can move some way forward. What is your take on that to both the judges I'm asking?
Yeah, I think we can certainly look at ordinary filing just to, so that the lawyers are not, feeling that they're underutilized and they're not usefully engaging themselves. So I think the ordinary filing through an e-filing process can be looked at.
Yes, sir.
I don't see any difficulty in that at all. It can be used for everything. Yeah.
Because no, sir, the take was the ordinary files are already scanned with the High Court itself, and the lawyers and let's assume there's an Advocate General Office or the respondent is there. He has the file. So the judges can access to the ordinary files. We can start moving with the ordinary cases which are already listed in the registry rather than simplicity posting it or to a different date. At least the urgent is having difficulty. The ordinary matters could be decided in some way or the other. That is few questions which have come on the WhatsApp.
I think as a suggestion, it can be put to the High Court. I'm sure the Chief Justice will take a call on this. See, I think what we are concerned is that the lawyers on both sides should be agreed on going ahead with the case. If they are and they stick to time limits. See, once you go online hearing, you have to stick to time limits. You can't possibly have one person taking up 2 hours, and they're spilling over to some other days and all that. An online hearing will require the discipline of, like Justice LOKUR pointed out, written submissions followed by submissions, and that both sides agree to stick to time limits. So again, we could try it out as an experiment. Let the request be made to the Chief Justice. I'm sure it will be considered.
I suppose the President of the Bar should be also the platform, because we personally feel that it is better to try and fail rather than failing to try. And if we continue to do something, there will be some positive signs for the betterment of this. So
yes,
that is the only take. So we are at 1:05 and 1:15. We were going to conclude. Questions which have not been able to be taken up. We are sorry to everyone, though the participation was huge on the WhatsApp as well as on the chat box. We are sorry we are running short of time. But before we go, I will just ask Justice LOKUR to give his inputs on the fact that how do we go look forward on the virtual platforms? How do we look forward to streamline the systems during these times? Let's assume we come over this pandemic and we have to be prepared for what has happened during these times.
Yeah, well, I agree with what Justice Muralidhar had said, that, there should be a dialogue between the lawyers and the court, right, on what are the problems that are being faced. E-filing may be easy, may not be easy. There may be some glitches, there may not be some glitches. Some improvements can certainly be made. There's always room for improvement. So I think that dialogue must take place. I mean, we just can't go ahead and say कि हाँ ठीक है हम कर रहे हैं तो बाद में देखेंगे. बाद में देखेंगे means when the बाद में come. So I think the move has to start now. Okay, and sure, I think programs like this that you have organized, Vikas, where there can be a sharing of views, that by itself will initiate that dialogue. So then, whether it should be an urgent case, not urgent case, whether it should be e-filed or not e-filed, all these things can be taken care of. So I think the dialogue must be there. Have a pilot project. Like I said, you can start off with a pilot project in Chandigarh right now, through the district courts. Maybe you can start that dialogue and have it in the high courts soon after that. But, I mean, the way things are going at the moment, there does not seem to be any plan. At least I'm not aware of any plan. And then suddenly when, on Monday, the lockdown is lifted, nobody will know what to do. We can't have a chaotic situation like that. So I think the time has come to have that dialogue. Yeah, thank you.
Justice Muralidhar, what is your take on that?
Yeah, one is, see, when it comes to all your recent technologies, the younger lot in the bar are far more conversant with gadgets, with technologies than the senior members are. So it's a sort of a reverse learning process, and we've all been through it. I mean, in our families also, our children and grandchildren are the ones who teach us how to use these gadgets and use the new technologies. So I would urge bar associations at all levels to locate those junior members of the bar who are conversant with technology, who find it easy to handle these systems. And like Justice LOKUR was saying, the younger members should be asked to audit that e-filing manual, which is already available. They will give you a feedback. They will tell you, listen, this is how you use it. Peer learning is the best when it comes to this. Any amount of training in an academy will not prepare the lawyer for actually using technology. It can be only peer-to-peer learning. I would therefore urge the bar associations to organize training workshops for lawyers, where the resource persons will be those junior lawyers who are very conversant with these technologies. Even today, we have young lawyers in the Delhi High Court who come up with designing apps for disseminating information on cases, on listings, and all of that. So at each level, whether or the High Court, I'm sure there are enough fully formed the COVID time, other times to be successful. Instead of everyone having to come to a High Court or come to another place, if the bar can organize, places where even senior members of the law of the bar can come and do the e-filing, the junior members can help the senior members do that. So this is a kind of a reverse learning that has to happen, and it's a wonderful opportunity for the bar, where the younger members and the senior members collaborate in taking this forward.
Mr. Balram Gupta, probably I have been just received a message from Amar Vivek. He has posted a question to you. Could you repeat? Could you post that question on?
That's right. See, the question that Amar Vivek has raised is with regard to the regular admitted cases, which are as old as 3 decades as such. How to manage those particular cases and what can be done with regard to dealing with those particular cases. That is what is his basic issue, which he has raised in the present situation.
Would just LOKUR like to go first, and then I can come in later?
Yeah, you go ahead.
See, I want Mr. Chatridge to be absolutely candid with all of us. Just tell us because you've had some experience, and even the person who posed the question probably is experienced. When these old matters are listed in any court, how often do lawyers actually turn up?
So the point what you have hammered is well taken. But one fact I've always believed is there are certain issues wherein the lawyers from both sides are actually interested to that. Let's assume there is an application. I go a step further. Let's assume a lawyer moves an application which is 20 years old. He moves an application for its early hearing. It clearly shows that there is a resolute from that lawyer and the party to go about it. At least some we can go about it where the early hearing of we can earmark, let's assume of 1985, 1990, the cases are there, and where there is an early hearing application, they clearly show the intent of the party to come and argue that matter. At least those could be there. Because as we say, I was just remembering while we were all going through the chat, what is habit? Habit is derived from the word it, bit, a bit, and habit. So we will have to cultivate a habit of doing work. Lest my saying this thing, I know that I can get into sticky waters once I go back to the courts. They said, no, you should argue the matter. You were quite ferociously submitting that they should be allowed people to speak.
Yeah, I can only tell you from personal experience of the Delhi High Court, whenever there's been an early hearing application in an old matter, and I just followed the examples of what Justice LOKUR and others do. Today and now, please go ahead and argue it right now. So judges are, I mean, at least from my personal experience, we're very happy to do these old matters if both sides agree. Our experience has been that this is the exception and not the rule. In 8 out of the 10 matters, we don't know if the parties are alive. We don't know if the issue is alive. If it's a criminal matter, we really don't know who is around. So there are numerous questions in criminal matters, old criminal matters. We end up appointing amicus curiae because we really don't have information whether the appellant is still available and wants to pursue his matter. So I think there are many issues on old matters. I completely take your point. There is an early hearing application. There should be no difficulty whatsoever, even in the COVID times. And if lawyers on both sides are ready for that matter to be taken up, and I would encourage lawyers who are ready in old matters to come forward to do it. And I'm sure the High Court will take up those matters. No doubt at all.
Vikas, I have just added, my own experience at the bar absolutely goes like Justice Muralidhar has just explained as such. You see, early hearing application, even in old cases, being opposed by the other party, not willing to argue the matter as such, that has been the major handicap in disposal of the old cases. That has been my experience as well. We need to really put a collaborative effort where both the parties agree and those cases should be taken up. Thank you.
Professor Gupta, the point has been well taken, but once there is a state counsel, in that case, probably there shouldn't be any hindrance because the state cannot oppose it. He has to be every time ready. As we say, they are the chowkidars of the litigation system. So they have to ensure that they cannot refuse it again.
Mr. Chatrat, I think you have to be practical in this. Our experience has been the state counsel will invariably say, I either don't have the papers or I need instructions, I need some more time. Which is why I'm saying, if both sides are ready and willing to go on with the matter, I don't see any difficulty in that happening.
Sir, the point is well taken. I remember when Justice Sanjay Kishan Kaul took over in our High Court, he said the sentiment that how the judge is handling the matter immediately flows. If you come to know that this judge will not give the date, 1 or 2 times he will say, and if he ensures it, then people are ready with that. Once you see the list, anything you do, you are always ready in the procedure that way. I understand that it is very easy said than done. Once we actually go to the platform, it's very difficult. Sometimes you're on the legs on the other side. Like that day I was reading the article of Mr. Tushar Mehta. He's saying, during the virtual platforms, how do we say that the lawyer is on his legs before the other court when the matter is being taken? So, as a one question, I'm just asking, Mr. Sapandhi has posted it. I can unmute Mr. Sapandhi. Mr. Sapan? This itself shows that sometimes we are also not. He says, Sapanth says, our filing system should be more accessible to the lawyers. And how do we make it? That's what we were saying. We should have videos so that people are assimilated the way, or not. Let's have a video. Anybody can come live from the High Court. He can give instructions. How do we go about it? Because during these times of e-filing and online filing, there's some mark of difference with this filing system.
It's a good suggestion. I think we should take that up. Yeah.
Because once we feel that there's some video, somebody, not video in a true sense, anybody who's well versed in the facts, he says this is the point 1, point 2, point 3, it's uploaded on the website, or even if he's willing to come on this platform also, sir, we will take it with both hands, because everybody is like the way we had the audience, people are going on the YouTube of this platform.
All right.
Sir, Alka has also posed one question. Alka Chatrath, I'm unmuting her, she can ask the question. And my apologies again to the people whose questions could not be taken because we are running, despite the fact that we want to make the schedule. It's yes, Alka.
Yes, sir. My option for the training of the newly recruited judges are that after the clearing the exam, they should be attached with the district judges or in the High Court judges to get the practical experience. There they can be given more training than before preparing for the exam. That would be the practical experience they can get while doing practical work.
Actually, the Delhi system, this is already being done. We do have trainee judges being attached both to district judges and in batches to High Court judges. In fact, many of them come to the High Courts for 3 weeks, sometimes even 4 weeks. And even in the district courts, they are attached to district judges, and this has already been done there.
Thank you, sir.
Vikas, I just add
Yes, sir.
one
Yes, sir.
particular observation. You know, the newly selected judicial officers who come to the Judicial Academy for foundation training, there is a pan-India schedule which has been worked out. They say work in the academy for a period of say 6 months, and that period is initially 6 weeks in the academy, and then they go for the court attachments. Come back, again we review, reflect upon their court attachment process and get the feedback, and then we tailor our further schedule to the judicial officers. This process goes on for 1 full year. They are attached with various, say the forensic science laboratory and other particular institutions which are so very relevant. They are given the practical revenue training. They are taken to the villages where actually all is taught to them. And therefore, we need to have a relook into this particular everything as to how the judicial academies are providing the foundation training, which was really. Thank you, Vikas.
Thank you, sir. Sir, we are already gone beyond the time. It's already 1:14, and we couldn't have called for a better session, a fantastic session. We are all enamored with the knowledge, insights given. And it is one of the rare platforms where we actually could have a dialogue both ways. Otherwise, what was happening was that हमारी बात हमारे पास रहेगी, आपकी बात आपके पास रहेगी. We couldn't move forward. At least we have certain points. We will try to see. I will ask persons to give us suggestions, and whatever suggestions we can give it in consolidated form. If there could be a common platform in the bar, in the High Court itself, where that could be posted out so that we can look forward, resolve the matters, because we are all more the senior advocates bar and the other bar members of where we are the members. We are all taking up the issues, but somehow it has not been resolved in the way it should have been. But an attempt is better than not to attempt it again. And thank you, Justice LOKUR. Thank you, Justice MURALIDHAR. And it was a very, we had always heard good about you, Justice MURALIDHAR. Justice Madan Lokur, while we had organized one webinar, not a webinar, it's got seeped in the mind so much that we had one workshops for 2 days on GPC. We had insights of Justice Lokur in the Judicial Academy where Professor Balram Gupta is there. We had always heard about Justice Muralidhar, but it is very rare that what you see and what you hear is the same thing. And Justice Muralidhar, I can vouch upon that. We had heard about you that your insights are good, but actually hearing you, it has the resolute and the feeling has got much better. I can vouch upon that upon the participants actually saying that we are more pleased, we are more happier than we could have thought. Hearing you and having your insights has been a pleasure to us. And over to Professor Ratan Singh to formally give a vote of thanks.
Thank you.
We are teamed up with UILS for this wonderful session. Thank you, everybody. Stay connected with us. Stay home. Those who want to have next webinar sessions, just connect us on our mobile number or the Facebook page of Beyond Law CLC for the further upsides. Tomorrow we are having Justice Kannan on securitization acts and the facets. And on Friday we are having Justice A.K. Sikri. On Saturday we are having Justice Anil Dave along with Justice Vineet Kothari on Benami Act. So stay connected, enrich yourself, so that once we go before Justice Muralidhar in the court itself or any other judge for that matter, we should feel that we are slightly, the tools of knowledge have got much better and we can place our facts much better. Over to you, Professor Ratan Singh.
Thank you, Vikasji. Thank you very much. Honorable Mr. Justice Madan Lokur, Justice S.MURALIDHAR, very briefly and very nicely, the roadmap which you have prepared as far as the legal reforms are concerned, it is really appreciable, and we understand the in-depth technicalities that where our judicial system is failing. Right, Honorable Justice Lokur, he said that we need to exercise the existing resources which we have, like Lok Adalat, mediation, arbitration, or many other e-courts and technology. And that is only the way by which we are to find better administration of justice. Similarly, Lordship Muralidhar fixed up about the core values as far as better administration of justice. And when he fixed up and discussed about fix up time cycle in order to adjudicate particular cases. And he also appreciated about the role of lawyers as far as the family courts are concerned. Here I feel like to refer one point that when we talk about reforms, judicial reforms, we are right from the inception of the constitution, we are fighting with this the system of the reforms. Many law commissions, many judgments of honorable courts has come into, but still this process is going on, and I'm very sure the suggestions and the guidelines which both the lordships has given, these will be worth for reforming our judicial system. So I, on behalf of Beyond Law CLC and University Institute of Legal Studies, Punjab University, I thanks to both the lordships, and thanks to Professor Balram Gupta ji, and thanks to all the participants. And probably this is a wonderful session. We have the much of the strength and participation. We are all enlightened with the your core discussions over there. Thank you very much, sir.
Only one fact before we part with. Tanu Bedi, who has been acting as an amicus, and she has attended the webinar on the first time, though invariably after giving the formal vote of thanks, we don't allow anybody. But once I read Tanu Bedi, I said that Tanu Bedi's, we will ask her input as an amicus on this platform, how to go about better, on this platform at least. She's amicus for this platform to increase better. Over to you, Tanu. Tanu? Tanu Bedi?
Can everyone hear me? I think something is wrong with...
No, Tanu, everybody can hear you. From sector 38, once you speak, we can hear you in sector 21 also. You are quite loud.
No, only judicial reform starts from within. So I had one question which I wanted to ask Justice Muralidhar personally also.
Yes, go ahead.
Probably the bandwidth is quite...
Am I audible to people? Because I can't say on my screen.
You can do that. You can go ahead.
All right. So, sir, I was just saying that. So, don't you think so that first of all, we should focus on what is to be a good lawyer, and then we can add to it that what it means to be a good judge, and then how we can dispense justice in a better way? Because we all expect it as a lawyer, we can do whatever we want to, but the moment we sit on the judge, something will happen, some light will come, and we will be away from all our prejudices, and will become super efficient. So I think the real training of judiciary reforms begins when we judiciary the day.
It's a rare occasion when Tanu की आवाज लोगों तक ना पहुंच पाए. But before we part, Tanu is a wonderful moderator as such. जाते जाते एक लाइन तनु से उसके बारे में कुछ सुन ले before we end the session. Thank you everyone. Stay connected with us. Stay safe. Stay home. Tanu, just one line before we part.
I have already spoken a lot. I think maybe because of my connection, it had not reached.
No, I'm saying only on the webinar. How do we go ahead? What is your feeling? And thank you. Your signature.
I think because you have done a wonderful job, and I personally believe in every adversity there lies an opportunity, and you proved it by doing these webinars for last so many weeks. So all of us have to look inside that we just don't have to crib. Courts are not functioning. This is not happening. Life is under curfew. Every adversity has a very big opportunity, and you proved it. And I'm really, really thankful to you, entire team of CLC, and the honorable judges who are here with us to guide us, to motivate us that, yes, we have a very beautiful future ahead of us. Thank you, thank you, thank you so much.
Thank you.
Thank you, Nanu. And thank you, everyone, sir. Thank you, Justice LOKUR, and thank you, Justice MURALIDHAR. Words can fall short. We cannot express the gratitude which the Beyond Law CLC and UILS has. And again, record breaking. Last time we had a record of 475. Today, straight away, 475 into 2 is 950. We had 960 participants. Thank you, sir. Thank you, everyone.
Thank you.
Thank you so much. Thank you.